Hello and welcome to LiveLaw Daily. I'm your host Debojit Das, and today, July 29th, is observed as the International Tiger Day, a reminder of the importance of protecting one of the world's most iconic endangered species and preserving their natural habitats. Back in India's courtrooms, however, it was another busy day with important rulings on citizenship, environmental regulation, free speech, and personal liberty. So, let's get started. Our first case concerns a Bengaluru-based doctor named Dr. Nagendra, who had alerted the police about a woman identified as Nazreena, alleging that she was staying in India illegally. On the night of July 22nd, the investigating officer wrote to the Foreigners Regional Registration Office recommending that she be detained and deported. But according to the doctor, just 15 minutes later, a counter-complaint was filed against him, leading to multiple FIRs and his arrest the very next day. Hearing the doctor's petition, Justice Nagprasanna strongly questioned the sequence of events, calling it a classic illustration of abuse of the process of law. The court observed that the doctor was the original complainant and asked how criminal cases could be registered against him when the complaint disclosed no injury or offense warranting such action. During the hearing, the judge made some observations, remarking that the legal system should not end up protecting illegal immigrants by prosecuting those who report them. He also questioned the state's conduct, asking how the police could entertain such a complaint in the first place, and expressed concern over landlords allegedly renting premises to persons without valid visas for financial gain. Finding a prima facie case in the doctor's favor, the High Court stayed further investigation in the FIRs against him. The matter will now be heard again on August 6th. Our second story today concerns a significant ruling on environmental governance, where the Supreme Court has held that projects cannot routinely seek environmental clearances after they have already begun operations. The case arose from a challenge filed by environmental NGO Vanshakti against a 2021 office memorandum which was issued by the Ministry of Environment. This had allowed projects that had commenced without prior environmental clearance to later apply for what is known as post-facto environmental clearance. Vanshakti argued that the policy effectively rewarded violators while disadvantaging those who complied with the law from the outset. It also contended that the memorandum had no statutory backing under the Environmental Protection Act and violated constitutional guarantees under Articles 14 and 21. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice Vipul Pancholi agreed, holding that the 2021 office memorandum could not create a permanent mechanism to regularize environmental violations through a mere administrative order. The court observed that such a framework could only be introduced through a valid statutory notification issued under Section 3 of the Environmental Protection Act. At the same time, the bench made it clear that its ruling would operate prospectively, meaning environmental clearances already granted under the 2021 policy will remain undisturbed. The court also upheld a separate 2017 notification, which provides a much narrower mechanism for dealing with environmental violations, while overruling earlier judgments to the extent that they had upheld the validity of the 2021 memorandum. Going forward, no fresh applications can be entertained under either the 2017 notification or the quashed 2021 office memorandum. However, the court clarified that the central government remains free to introduce a similar, narrowly tailored mechanism in the future, provided it is done through a valid statutory notification. And our third story today comes from the Kerala High Court, which has reiterated an important legal principle on citizenship, holding that documents such as voter ID, Aadhaar card or PAN card by themselves are not conclusive proof of Indian citizenship. The case arose from a habeas corpus petition filed by the uncle of a man who had been detained as an alleged Bangladeshi national. The family contended that he was an Indian citizen and pointed out that his name had initially been kept under adjudication during the 2026 Special Intensive Revision of Electoral Rolls before being deleted, with an appeal against that deletion still pending. To support their case, the family produced a series of documents, including the detainee's voter ID card, Aadhaar card, PAN card, bank records, ancestral land records, and even the passport of his paternal aunt. However, a division bench of the Calcutta High Court held that none of these documents, either individually or collectively, conclusively established Indian citizenship. The court observed that a voter ID only proves enrollment in the electoral roll, while Aadhaar, PAN cards, and bank accounts are not documents conferring citizenship. It also found that the land records and the relative's passport did not establish the detainee's own nationality. The bench further reiterated that once the authorities allege that a person is a foreign national, the burden shifts to that individual to prove citizenship under the Citizenship Act of 1955. Finding that the petitioner had failed to establish citizenship by birth, descent, or registration, the High Court declined to interfere with the detention ordered under the Immigration and Foreigners Act of 2025. And our fourth story today returns to the issue of examination integrity, but this time from the Parliament. The Lok Sabha has passed the Public Examination Prevention of Unfair Means Amendment Bill of 2026 by voice vote, significantly strengthening penalties for paper leaks and other examination malpractices. The legislation comes in the wake of nationwide protests over the NEET paper leak, which ultimately culminated in the resignation of Union Education Minister Dharmendra Pradhan. Under the amended law, the punishment for using unfair means in public examinations has been substantially enhanced. The minimum prison sentence has been increased from 3 to 5 years, while the maximum has been raised to 10 years. The maximum fine has also been increased from 10 lakh rupees to 50 lakh rupees. The bill imposes even stricter consequences on organized examination fraud. Service providers found complicit can now face fines up to 5 crore rupees and be barred from conducting public examinations for 8 years. Directors and senior management found involved in such offences will face a minimum sentence of 5 years, while organized crime relating to public examinations will now attract a minimum 7-year prison term and a minimum fine of 10 crore rupees. The amendments also aim to speed up prosecution. Investigations must now be completed within 2 months, while every state will designate a special fast-track court to conduct day-to-day trials, with cases expected to be concluded within 3 months of the filing of the charge sheet. Appeals from these courts will go directly before a division bench of the High Court, which is also expected to decide them within 3 months. The new framework allows the recent establishment of special courts in Delhi and Maharashtra too, which we have reported on over the last few days. Our next story today comes from the Bombay High Court, where the owner of the iconic Allahabad Bungalow, once home to Bollywood legend Rajesh Khanna, has secured interim protection against what he says is defamatory reporting. The suit was filed by businessman Shashi Kiran Shetty, who now owns the Carter Road property in Mumbai. Although the original bungalow has since been demolished and reconstructed, Shetty has retained the name Ashirwad. He approached the High Court after several media outlets and YouTube channels published videos describing the property as haunted, cursed, unlucky or ill-omened, with some even suggesting that it had ruined the careers of 3 Bollywood superstars. Appearing for Shetty, senior advocate Dr. Birendra Saraf argued that such publications were defamatory and violated his client's right to dignity and privacy. He also sought directions for the removal of the offending content. Hearing the matter, Justice R.F. Doctor found that the plaintiff had made out a strong prima facie case. The court observed that the material appeared to be defamatory because it portrayed the plaintiff as living in a haunted or cursed house and interfered with his right to live peacefully and with dignity. The court also noted that despite being served, none of the respondent media houses or YouTube channels appeared before it to justify or defend the publications. Observing that the content appeared to have been created merely to generate sensationalism at the plaintiff's expense, the High Court granted ad interim relief. And accordingly, the court restrained the respondents from publishing or circulating content referring to the bungalow as haunted, cursed, or unlucky, and directed them to file their replies before the next hearing on August 21st. Our next story today comes from the Allahabad High Court, where an advocate approached the court with an unusual public interest litigation, seeking directions to ensure that court proceedings begin exactly on time every day. The petition was filed by Advocate Arun Mishra, who relied on a 2008 full court resolution prescribing court hours from 10 a.m. to 1 p.m. and then 2 p.m. to 4 p.m. He alleged that on May 5th, several courtrooms had started proceedings a few minutes late, some at 10:05 a.m., some at 10:10 a.m., and even some at 10:30 a.m. He also claimed that similar delays occurred after lunch and sought directions requiring any delayed sittings to be displayed on notice boards and reflected in the daily cause list. However, a division bench of Chief Justice Arun Bhansali and Justice Kshitij Shailendra found the petition to be fundamentally flawed. The court observed that the petitioner had only pointed to the time at which certain courts assembled, but had failed to disclose whether those courts later sat beyond the prescribed hours to make up for the delay. The bench noted that a slightly delayed start did not necessarily mean that judicial work had suffered. The court also held that the relief sought was legally untenable because it effectively asked the High Court to issue a writ of mandamus against its own judges, something that could not be entertained. Calling the petition misconceived, the bench dismissed it. Our seventh story today brings us back to the Supreme Court, which has once again underlined that even in cases under the Unlawful Activities Prevention Act, prolonged incarceration without meaningful progress in trial cannot override the constitutional guarantee of personal liberty. A bench of Justice Vikramnath and Justice Sandeep Mehta granted bail to Mohammad Shakib Ansari and Waqar Azhar, who have remained in custody since 2014 in connection with a Delhi Police special cell case registered under the UAPA. They had approached the Supreme Court after the Delhi High Court refused them bail under Section 43D5 of the Act. While examining the matter, the Supreme Court looked at the status of the trial through the e-courts portal and found that progress had been painfully slow. Out of the 197 prosecution witnesses, only 68 had been examined so far. Even more striking, since January 2025, only 2 witnesses had been examined, one of them only partially. With 25 persons accused facing trial, the bench observed that there was no realistic possibility of the proceedings concluding anytime soon. The court also noted that the petitioners had already secured bail or suspension of sentence in 2 connected Rajasthan cases arising out of substantially similar allegations, and that a co-accused in the Delhi case had already been granted bail. Taking all these circumstances together, the Supreme Court held that keeping the petitioners behind bars for nearly 12 years, despite the trial moving at such a slow pace, amounted to a violation of their fundamental right to personal liberty under Article 21 of the Constitution. Accordingly, the court directed their release on bail, subject to conditions to be imposed by the trial court and provided that they are not required in any other case. Our next story comes from the Bombay High Court, which has quashed the externment of a leader from the Social Democratic Party of India, after finding that he had been singled out for participating in protests against decisions of the central government. The case concerned a member of the Social Democratic Party of India who had been externed from Mumbai for 1 year. The state relied on 3 FIRs registered against him in 2024 and 2025, one relating to protests against the Waqf Amendment Bill, another concerning sloganeering over the demolition of the Babri Masjid, and a third involving a protest over air pollution in Chembur. However, Justice Madhav Jamdar found that the state's action was selective. The court also noted that the protest against the Waqf bill had also been attended by leaders of the Nationalist Congress Party and Shiv Sena led by Uddhav Balasaheb Thackeray, along with local residents too. Yet, externment proceedings were initiated only against the SDPI leader. The state argued that slogans raised during the Babri Masjid protest could create divisions in society. But the court found that no material had been placed on record to support that assertion. Holding that all 3 FIRs stemmed from protests against government decisions, the High Court observed that the authorities had failed to explain why similar action had not been taken against participants from other political parties. The bench concluded that the externment order was arbitrary and illegal. Referring to earlier decisions of both the Supreme Court and the High Court, Justice Jamdar further held that such arbitrary externment orders infringed the petitioner's fundamental rights to free speech and free movement. The externment order was accordingly quashed. And we end today's edition with a case that brought together freedom of expression, religious sentiment, and artistic creativity before the Supreme Court. The Supreme Court refused to halt the release of the animated film Mahaprabhu Jagannath, dismissing applications filed by the Jagannath Temple Administration and a devotee seeking to modify an earlier order that had permitted the film's release after the conclusion of the Rath Yatra in Puri. The applications argued that depicting Lord Jagannath in animated form hurt religious sentiments. They also claimed that during a special screening, several religious leaders and members of the temple committee had objected to the portrayal and that the producer had agreed to make changes before release. However, a bench of Justice B.V. Nagratna and Justice R. Mahadevan declined to interfere. During the hearing, Justice Nagratna observed that if courts started banning artistic works merely because a few people found them offensive, it would become impossible to depict stories from the Ramayana, Mahabharata, or Hindu mythology in any artistic form. She remarked that artists and creators could not be held to ransom simply because a handful of individuals disagreed with their work. Justice Mahadevan also noted that the film had already received certification from the Central Board of Film Certification. Counsel for the producer denied giving any assurance to modify the film and submitted that the Temple Committee had itself walked out of the special screening. Dismissing the applications, the Supreme Court refused to modify its earlier order allowing the film's release. At the same time, the bench observed that if the producer wished to make any changes voluntarily, he was free to do so according to his own conscience. But the court would not sit in judgment over that decision. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of these stories in detail, you'll find the links in the description box below. For continuing coverage of the courts and the law, visit livelaw.in. Thank you for listening and keep following LiveLaw for everything that is law.